Yesterday was called for lordship. May I pray lordship, let this matter come up day after tomorrow, lordship. Lordship probably remember that they have made a prayer that whether POXO was added or not. That lordship.
Can I proceed?
Item
23, lordship.
Wednesday.
Obligation.
I'd like to mention item number 42.
Yes.
This matter, Your Honor, we have filed a joint affidavit on 19/6/2020. The same has not been. So we would like to bring it on record today as the matter has been compromised between the parties. That is a settlement agreement. Your Lordship may allow us then.
$42. This.
Praying for a listing of a bail application, Lordship. Another connected matter is fixed before your Lordship on tomorrow.
Tomorrow.
Obliged.
My lord, I beg to mention item in matter,
15.
yes, down to 25th of June.
Pardon?
Matter be adjourned to 25th of June.
No, it will go after vacation. Already fixed too many matters.
15th of July.
Already.
May I please, Your Lordship? Lordship, in item number 12, today daily list, Lordship, we have to file an affidavit, Lordship. Kindly fix it. For 2 weeks.
Criminal petition.
Yes, my lord. 791.
What is the urgency after vacation?
Obliged.
May it please your lordship. With respect to item number 13 of daily list, lordship, my learned friend is appearing for the respondent, lordship. We have joint prayer. Let the matter come up immediately after vacation, lordship.
All right. Item 13. 13.
Yes, lordship. 13. Prasanta. Number 2 and myself, lordship. And also in respect of item number 14, lordship, I am not seeking an adjournment because I could not obtain the consent, lordship. I might not be there, lordship. My junior colleague will be there, lordship. Kindly accommodate. I will be appearing
Respondent number
2 in item number 14, lordship. First, consent was not taken, lordship, so order may not be passed at this point of time.
Obliged, lordship.
In item number 41, a report was called for. It is regarding the Jimma of a coal seized by the police. But time said that the report is not available to them. It may issue reminder. The
report is called for has not been received. Issue reminder list again on vacation.
16 July 41.
Hey, please, Your Lordship. Your Lordship, a matter was listed on the 18th, Your Lordship, criminal appeal jail, and Lordship had thereafter fixed that case for today. Because, Your Lordship, only 41 days had remained, and Your Lordship, it was with regard to service of notice in a POXO case, Lordship. I have given the order, Lordship. However, it has not been listed today, Lordship. Therefore, I'm praying for it to be listed tomorrow or day after, as per Lordship convenience. Lordship.
May I please, Your Lordship? I beg to mention for listing of a review petition on Thursday. My lord has passed the judgment on 10 June, my lord. It's regarding my lord Sarmila Bijay Sethi and Gauhati Tea and Trading Company. One FAO has been disposed of by this honorable court. There are submission has been made by the respondent, my lord, but it was regarding consent has been given, but there are some needs to be reviewed on that submission, my lord. On Thursday, my lord.
Oh no, after vacation.
Finally, there is an urgency, my lord, that our consent has been recorded in the.
When was the order passed?
My lord,
What is the date of the judgment?
10 June, my lord.
10 June.
10 June, my lord.
So what is the urgency?
And it Thursday, my lord, small activity.
The review full is
Review, my lord.
it is a judgment.
My lord.
So it's a review. It will take a hearing.
My lord,
If you file a review.
on Thursday, my lord, if can it take
No.
up, my lord.
After vacation.
Can it be a date? Will be given.
So that
Date we have to.
to file, it will anyway automatically come up after vacation.
16 July. Obliged, my lord.
Non-appears লিখে পিছত দি পিছতে মাতি দিব পিটিশন নাই
Maybe FIR is on page number 10. I did. With due respect,
person is dead.
Pardon?
He is dead. Victim.
Victim is the no. Victim is the complainant himself.
What?
Victim is not dead. He is not at all even severely injured also. Victim date of occurrence is 16/5. The victim himself went to file the FIR on 18/5, 2 days after.
Not only the victim, another person also sustaining.
Yes.
So at this stage, the city may be confirmed.
I am behind the bar for last 27 days and I am not at all involved. 15 to 20, FIR itself saying that 15 to 20 people attacked him, but no injuries there.
Right, CD.
Your lordship, matter may be fixed tomorrow because other matter relating to this particular your case
give the
number
case
is
number.
fixed. What are the case? List of years. List of years. Yes. Well,
Already corrected.
Yes.
Is the matter alone?
page number 2. What are the issues?
Yes, call.
Item number 1. York, maybe, no, yes.
Wait, please. Sir, regular bail manner. The lordship will kindly have a look at page 16 manner, the FIR manner. The lordship will kindly see manner the reference manner. Page 16 manner.
Very long FIR.
The reference manner. Yes, manner. Hailakandi PS manner GDE number 36 dated 23/5/26 manner. The next first line manner. I respectfully begs to state that on 23/5/26 at about 11 p.m. information was received from the respected so-and-so regarding an online cyber fraud scam. Complainant lost by one person, namely Sunil Malar of Maharashtra. It was informed that the complainant had allegedly been cheated by certain fraudsters operating from Hailakandi district, Assam, through online fraudulent activities. The complainant also submitted an online cyber complaint bearing complaint number so-and-so before the concerned authority. It was further informed that during the preliminary verification of the complainant, it was revealed that the cheated amount have been credited in the bank account of one person, namely Bapanuddin Mojumdar. I am not Bapanuddin Mojumdar, my lord. Upon receipt of the said information, the officer in charge, Hailakandi Police Station, after making necessary GD entry, write reference number so and so, endorsed the matter to so and so for immediate enquiry and necessary action. Accordingly, as per the instruction of SI Ranjan De, myself along with him accompanying staff started enquiry into the matter. During enquiry, details of the suspected amount were verified, and it was found that the account holder, namely Bapanuddin Mozumdar, is a resident of so and so, under Hailakandi police station. On the basis of the above information and during the course of enquiry, it appears that the said persons were directly concerned with the receipt and handling of the defrauded money obtained through cyber fraud activities. Accordingly, SI Ranjan De, along with me and staff, proceeded towards so and so with the help of PTL for apprehending the suspected accused person and conducting further inquiry. On arrival at so and so, the suspected accused person, Bapanuddin Mozumdar, was traced out and apprehended from his residence in the presence of the local witness. During preliminary interrogation, he admitted that an amount of rupees so and so have been credited into his bank account bearing account number.
So you are named here?
No, my lord. I am not Bapanuddin, my lord.
No, no,
Next.
you're Masud Zaman.
Yes, my lord. My lord, I was arrested on, my lord. That's the point, my lord. Only the legal submission, my lord. I was arrested on, my lord, 23/5/26 at around 12 o'clock in the midnight, my lord.
Oh, for all that we have to see the CD.
Yes, my lord. Now the next, your lordship will see, my lord, I have been produced before the court below. That is at page 18, my lord, on 25, my lord. And moreover, my lord, all these sections are, my lord, below 7 years, my lord. And my lord, the no notice has been served, my lord, as required under section 35(3), my lord. That's the only 2 point, my lord, at this stage, my lord. Whether I was arrested, whether I was produced before the court within 24 hours, and secondly, my lord, no notice under
Yes,
section.
exactly. For that we have to examine the
Yes,
reports.
my prayer before lordship, my lord, lordship can ask the additional PP, my lord, to ascertain whether the notice has been served under 35(1), my lord.
Call for the CD.
Lordship may obviously call, my lord, that instruction, my lord, whether the notice has been served under section 35(1), my lord. Because all the sections, my lord, are below 7 years, my lord.
It may fix it on Friday.
All right. Even if no notice was issued,
No notice.
provided there is justification for
Justification.
arrest recorded in the CD.
Yes. However, in the forwarding, my lord, it is silent, my lord. Take a chance on, my lord, Friday. 27. I'm obliged.
Item 1.
Withdraw. Yes. You are Mr.
A high on behalf of M. Ahmed.
Huh?
A high on behalf of M. Ahmed.
Withdrawal of the petition. Allowed. Dismissed as withdrawn.
Bless you.
Please, your lordship. This is a substituted case. This present petitioner was arrested on 25/3/2026 on the strength of a PNA issued by the Learned Court of CGM Sonitpur, lordship. Till then, he is behind the bar, lordship. Lordship, here in this case, lordship, no someone was served upon the petitioner, lordship, and he had no knowledge regarding the pendency of the case, lordship. Had he been served any copy of the summons or had been the knowledge of pendency of this case, lordship, definitely he would have appeared before the court. But the Learned Court, I have annexed all the orders, lordship, and lordship will find that no summon was served upon the petitioner, lordship. But as the PNA was issued, then he was arrested and he was produced before the Learned Court of CGM, and accordingly he was put behind the bar, lordship. And thereafter,
Person is there, then you don't even know case is going on.
no, lordship, no summons were served, lordship. That is why he could not come. Once the summon has been served, lordship, I am enclosed all the documents, lordship, can find. All orders have been annexed, lordship. PW has issued on 13/6/2024, page number 39, Lordship.
When were you taken into custody?
On 25/3/2026, page number 50, Lordship, order.
All right. Anyway, it is a 302 case. Even if you had appeared, you would have been
Page 28.
taken into custody. Let's call for the TC.
28, there is an order, my lord, someone issued to him has not returned. This year.
Lordship.
Please allow timing in this matter at 2 p.m.
Later, anyway.
Councils are
Him come. Time being. Sir, Martin.
May I please, Honorable Court, may I please, Honorable Court. Request for, also, as my senior is engaged with some other court
Even today or some other day?
today.
And it take after some time, Lordship.
My lord, kindly pass over the matter.
What is this going on?
Lord, she is busy with court number 5.
বাকী বিলাক মাতি দিয়া হ'ব।
May it please, Your Lordship. Your Lordship, anticipatory bail application. FIR is at page number 11, Your Lordship. May I read the FIR? Respected sir, with due respect and humble submission, I'd like to inform that on 4th of May 2026 at about 9:30 p.m., when my husband was at his workplace at Hojai town and he sent one of our neighbor nephew, namely Azimuddin, son of this and this, some to our house with some ration for our family. At 10 p.m. when he reached at my house, that below detailed accused persons along with some other anonymous persons suddenly entered into my house and started to beaten up me as well as the said person. The group of accused persons started moral policing by alleging that I and the said person was engaged in extramarital affairs, which is totally false and their manufactured story. The accused person had beaten us brutally by way of tying our hands and legs on the tree, for which I became senseless, and then Murajar police reached at the place of occurrence and took us to the police station. The below named accused person number 10 has viral the video photographs of beating with some bad captions. I therefore request you to good self to admit this FIR and take necessary legal action against the accused persons. Your Lordship, the actual case is that in villages there is a VDP party which is active every night, Your Lordship. Here, Your Lordship, accused number 9, he is one of the Nayaks of the VDP party, and this boy very suspiciously, when they tried to stop, he entered into the house of the informant, Your Lordship. Thereafter, it is true that a lot of people gathered at this place, but it is untrue that they even attacked him physically. The main purpose of the VDP is to call the police. The VDP called the police, and police came there and took the situation in their hands, Your Lordship. There was no such act of assault or any kind of attack on anybody, Your Lordship. Moreover, Your Lordship,
And the one person, he has been already arrested, accused number 7, for whom we have not preferred this anticipatory bail application. And the rest of the people were just present at the location, which they have paid correctly as moral policing.
Who has been arrested?
Accused person number 7 in page number 12, Sultan.
Where is his forwarding report?
He has been arrested, Your Lordship, most probably after we have filed this anticipatory bail, Your Lordship.
Then
Only just to bring it to the record of the court, Your Lordship. And otherwise, Your Lordship, all of them are just a part of the larger group, Your Lordship. Nobody attacked individually.
CD will reveal what. Clarification.
Deeply obliged, Your Lordship.
The appeals. So this is my anticipatory bail application. Lordship, my lord, already heard with the matter, my lord, what a co-accused, Lordship, granted bail, my lord. I am on similar footing, Lordship. I was also a handyman, Lordship. I have stated, my lord, on that date. FIR will be, my lord, at page number 14, type copy, Lordship. Regarding my lord, ONGC pipe, my lordship. Only the main diver, my lord, arrested, Lordship. He has also granted bail by the court below, Lordship. I mean, time, my lord, another co-accused across this honorable court, Lordship has granted bail, Lordship, on the ground of, my lord. There's no 35 notice. It is number 24, Lordship.
who are you? That other guy was a handyman.
Handyman, Lordship. I'm also a handyman as well as my driver. On that particular, my lord, I was handyman, Lordship. I'm also a my lord, under STC, my lord, driver, Lordship.
What is your name?
Anupam Raskumar.
Where is the FIR?
FIR, Lordship, type copy, page number 14, Lordship.
His?
Page number 14, Lordship. 1-4. Type copy. My name is not Dallas, but police is calling you, my lord, without issuing notice. I want to appeal also. I will quote. My name is not there. Driver is my lord, Hirokjyoti Ghorpulia, my lord. He has already arrested, Lordship.
Appears to be on the same footing. Anupam Raskor, no, August was order dated on page 24. Same order, Namtu, Anupam Raskor, Novosity. All for the case diary jota se tata eta add kori diba.
Lordship, may please conduct.
Another co-accused Novosity Mohan granted interim pre-arrest bail by order dated 06/26 AB 1297 2026. এইখিনি একে থাকিব ডেটটো একে থাকিব
May I please, Lordship? Lordship, FIR is page number, my lord, 12, my lord. My lord, in the same FIR, my lord, the prime accused number 1 has already got bail, my lord, from this honorable court, my lord.
This is a charged matter, my lord.
Charged matter, my lord. And 326 and 307 is there, my lord, but this honorable court observed that 326 and 307 may not be attracted in this case, my lord, in this order, my lord. Simple injury, my lord.
Any order to
Your name is?
M.H. Soikia, my lord.
Huh?
M.H. Soikia.
No.
Accused number 228, my lord. There are 8 accused person, my lord.
Where is the FIR?
FIR page 12, my lord. The accused number 1 has already got bail, my lord. Saiful Islam.
You are Rafiq Ali, Samsul, Nurul.
No,
Abdul-
Nurul and Raihan is not our case, my lord. We are 6, my lord, 6 accused persons.
Nurul and who? Not there.
Nurul and my lord, Raihan already searched FR, my lord. Raihan name has already been excluded, my lord. Abdul Nizamuddin.
He is representing Rafiqul, Abdul Kader, Nazimuddin.
সেইকেইটা নাম ভৰাই দিবা এইখন অৰ্ডাৰখন আছে সেম অৰ্ডাৰ হ'ব তাতে দিবা এনেকে বাই অৰ্ডাৰ ডেটেড Prohibitions was granted by it order.
Simple injury, madam.
Yes, simple injury.
Because that order is not enclosed here, so.
Filing of this case. Keep your my lord.
I don't know.
Maybe disposed of my
Was it disposed of earlier?
earlier.
Oh, it was after CD.
After city, my lord.
It is also disposal.
Yes, disposed.
Bless my lord, deep purpose.
গোটেইকেইটা হৈ গ'ল নেকি এইবিলাকৰ পৰা এইবিলাক হোৱা নাই নেকি 767
Maybe please, your lordship. Lordship, on last occasion, I have been appointed as amicus curiae by this honorable court, lordship.
Yes.
Yes, lordship, basically this review petition has been preferred for quashing of the ex parte order dated 18/11/2004 passed by the SDGM Tezpur in a miss case number 160 of 2003. So that impugn order is at lordship page 14, Annexure B, lordship.
Eighteen
18/11. May I read, lordship? First party present says examine ex parte, peruse the evidence of first party, also peruse the petition of first party. After careful perusal of record, it reveals that first party is one usually married wife of second party and second party is the father of 3 minor children of first party. It reveals that second party neglected to maintenance first party and had 3 children. They were unable to maintain themselves, but second party got sufficient means. So I find it is fifth case for granting maintenance, and accordingly second party is declared to pay maintenance to the first party and her 3 minor children for rupees 400 only each per month. The order for maintenance will be effected from the date of this order. The case is disposed ex parte. So basically this order has been challenged by the petitioner, and subsequently when the maintenance one not paid, so the respondent number, opposite party number 1 file 1 petition, lordship. This is a next order, lordship, 22/6/2005, lordship. Then subsequently, lordship, NBWA was issued. But from the record available, lordship, it cannot be ascertained on which date the NBWA was issued. Because on page 15, the order dated 9/2007, it reflects that prior
Is
to this-
challenging which order, the granting of maintenance or the NBWA?
Yes, first is challenging the 18/11/2004 order, lordship. So his basic ground is that he has not received the notice of that case, lordship.
paragraph number 3, Lordship, of the this petition, Lordship, he has taken the ground, Lordship, because the address was not proper. His the name of the father's name of the petitioner was wrongly mentioned, as well as the name of his village was also wrongly mentioned, Lordship. Paragraph 3, Lordship, may I read, Lordship? That the petitioner states that he is a daily laborer, and by doing his duties, he maintains his big family. Meanwhile, the opposite party number 1 first party misguided him to remain separately with her and children, leaving his entire family members. But he refused to do so, and then the opposite party number 1 emotionally and willingly came out from her husband's house and filed a case for maintenance, wherein she made some false and concocted allegation against the petitioner. During the pendency of the case, no notice was issued to the petitioner, and he did not receive a single notice. And also, he was not informed about the case, for which he was totally unknown about the case, and as such, he could not proceed the case at all. Perhaps the opposite party number 1, first party, could not put proper address of the petitioner in her maintenance case. In the trial court, the complainant filed the case with wrong address, whereby the father's name of the petitioner, second party, was written as Bosaruddin in place of Muhammad Badaruddin. And also the name of the village has been wrongly written as Bishmati in place of number 3 Borwajar, which are the complete different villages. And the name of the district has also not been mentioned in the complaint case. For this reason, perhaps notice was served, but it was not communicated due to lack of proper address. And for this proceeding, the petitioner is totally responsible for his absence in the trial court. He was not deliberately absent in the trial court. In fact, he was totally unknown about the case of the trial court. In this regard, the trial court was pleased to observe by passing an order dated 14/7/2009, whereby it was observed that the wrong address was written in the maintenance case. The father's name, village name, and district has been wrongly written in the petition, for which the notice was not served on the petitioner, Lordship. In the cost title, Lordship, as page 2, if we see, Lordship, the name of the father of the petitioner is Muhammad Badaruddin, and the village is number 3 Borwajar, post office Besimari, PS Dolgaon, district Darang, Assam. It is, Lordship, the
What was the address in the petition?
yes, Lordship. At page 9, Lordship, translated copy. Opposite party Muhammad Akas Ali, son of Muhammad Bosaruddin, and village Bishmati, PS Dolgaon, Mongoldoy, Assam. So village name and the petitioner father's name was different, Lordship. So there might be a possibility of not receiving the notice, Lordship. And the petitioner came to know about the case when the police visited his house only, Lordship, in 2010, Lordship.
But this is of 2016.
Yes, one criminal miscase was there, Lordship. So so delay was condoned. Lordship, that criminal miscase number 410 of 2010. It is in the record. By 11/5/2016, by this honorable court, Lordship, the delay was condoned, and registry was directed to register this criminal revision petition. And there is also a miscase along with this revision petition for staying the operation of that NPWA order, but no such order in that regard has been found in the record, Lordship.
What about service of notice in this revision on the wife? Nobody has appeared.
Nobody appeared, Lordship.
Was the notice complete? Did anybody appear in the condonation petition?
No, Lordship.
There is nothing in the office note to show whether.
Notice was.
Yes. We'll be doing the same thing what was done there. Here also without notice. Since there is nothing there here to show whether notice was served or even issued.
Lordship.
It is recorded in the delay containing order that notice was issued to the respondent on several occasions, but she was not found in the given address. And in spite of best efforts, notice could not be served, and it was reported she left her place of residence long back. And now she may have been married to somebody else also. We don't know.
Perhaps, Lordship. The petitioner was perhaps not given the proper address also.
That is also possible.
The order of 2004, Lordship. 22 years have been passed, Lordship.
Even know whether he is even alive.
Yes, Lordship.
2004 matter.
4 matter, Lordship.
At least till 2016, he appears to have been alive when delay was condoned.
Yes. In 2022 also, Lordship, that counsel for the petitioner appeared. He submitted that interim prayer considered in 2/8/2022 in the main revision petition, Lordship. Some order was there. Counsel for the petitioner appeared, Lordship. Thereafter, Lordship.
So I think we, instead of, because we neither know whether either party is alive or an order of 2004, obviously nothing is happening in that case. Kind of a dead case. So even if we set aside this order on the ground of non-receipt of notice, and if the parties are, or either of them are not in existence, then it will be another proceeding for the trial court. Another case will be keep on pending there. Why not call for a report from the police whether this person is available or not?
Very well, Lordship.
Alright, heard learned counsel for the petitioner and heard learned additional PP. None appears for, no, learned in the amicus curiae, okay. None appears for the respondent. The order impugned in the present proceeding is of the year 2004. The petitioner had approached this court in the year 2010 as he had not received notice of the proceedings. The delay in approaching this court was ultimately condoned by order dated 11/5/2016 in criminal miscase 410 of 2010. Thereafter, the instant criminal revision 149 of 2016 has been registered. In the aforesaid order dated 11/5/2016 has been recorded that notice was issued to the respondent on several occasions, but she was not found in the given address. In spite of best efforts, notice could not be served, and it was reported that she has left her place of residence long back. Full stop. Para. The order sheet of the instant case reveals that now the petitioner himself has stopped appearing, as none had appeared for the petitioner since (12/8, 2022). Full stop. Last date on which learned counsel for the petitioner had appeared was on 02/08, 2022. Accordingly, Sir so-and-so was appointed as amicus to represent the petitioner. Sarah, having regard to the long pendency of this case, before proceeding further, it is considered necessary to ascertain the stand of the petitioner himself, or as to whether is still available. Accordingly, call for a report from the officer in charge of the concerned police station. What will that be?
Sonitpur also. Sonitpur. The petitioner is from Darang, and the opposite party number 1 is from Sonitpur also.
Is PS Dolgaon?
Yes, Dolgan.
Akash Ali. You are Akash Ali?
Yes, Lordship.
Proceed PS Dolgaon, whether the petitioner Muhammad Akash Ali, son of Muhammad Badaruddin of village number 3, Boruajar, Barua Jhar, PO Bechimari, PS Dolgaon, district Dorong, is still available. Also call for a report. Respondent, I think, since already a finding is there that she is no longer available, we may not need to call for a report again.
Yes, if we find this.
Because that matter has already been.
Yes, if we find a petitioner, then he will also be able to
Raise the matter again on so and so registry to communicate this order to the OC Dolgaon PS.
oblige. Please.
Please, Your Lordship. No, this is anticipated bail application, my lord. Charge sheeted case just filing after charge sheet. My lord, trial has started. Next date 30 June 2026 for appearance. My lord, kindly the page number 13. That is FIR, my lord.
Case number 13 FIR, my lord. In this case, my lord, the petitioner is not a FIR name accused, my lord, just co-accused, my lord. Even, my lord, after received the summon, my lord, the learned counsel appear before the trial court on behalf of me, my lord. Case number 50, my lord, that is order issued by the SDGM Dhubri, my lord. This case, my lord, the FIR number 4 person, my lord, they are arrested, subsequently released on bail, my lord. They are appearing the trial court, my lord.
Charge sheet has been filed
Yes, my lord.
against you,
Against 7 person, my lord.
including
My number
you.
is 7, my lord. No allegation mentioned in charge sheet, my lord, against me, my lord. Just a name put up, my lord. And 4 person are the main crime accused, my lord. Crime accused, my lord. They are arrested and released by the way subsequently, and they are appearing on the trial court, my lord. Now, my lord, the present petitioner is ready to appear the trial court, not face trial, my lord. Just, my lord, needs the protection, my lord. As because my lord section is non-relevant, my lord, and showing me as conduct, my lord, in charge sheet, my lord. My lord, page number 50, my lord. Need to protection, my lord. I am ready to appear the trial court, my lord. Next date fixed on 30 June, my lord.
Where is the bail order?
Page number 50, annex of 3, my lord. This is order by the learned SDGM Dhubri, my lord.
50.
50, my lord. Last page, my lord. Not bail order, my lord. Order was passed, my lord, by the learned counsel for the appearance. Fixed for appearance, my lord. And engaged counsel already appeared before the trial court, my lord, on behalf of me, my lord. For taking time, my lord. 4 person are present, my lord, on that day, my lord. I have to appear the trial court, my lord. I need to protection, my lord. I am ready to appear trial court, my lord, face trial, my lord, because I am innocent, my lord. And no allegation mentioned in charge sheet, my lord, against me, my lord. Any one allegation, my lord. Please file the charge sheet, my lord. Crime because 4 person were arrested and subsequently released, and they are appearing before the trial court, my lord. They are the main crime because, my lord.
Yes, PP.
During entire investigation, their conduct, my lord, they were absconding, my lord.
My permanent residence is there, my lord. I am 50 above years, my
Permanent
lord.
residence
Having,
was
my
there
lord, children,
since
and my
earlier.
lord, the police person, I will never visit my house, my lord. Never, any day, my lord. That is why my name has been recorded as mistakenly, my lord, Syed Ali. My name is Syed Ali Sheikh, my lord. And even, my lord, in FIR, my lord, page number 14, my lord, there's an interesting point, my lord, I mentioned, my lord. Kindly come to the page number 14, my lord. Page number 14, last 3 line, my lord. Page number 14, last 3 line, my lord. Very interesting, my lord. Later on, the accused person took us the Palpara 6 p.m. when the accused person were distracted. Then we attacked the accused person, my lord. My lord, how it is possible, my lord? 2% informant, my lord. They are belongs to Bangladesh, my lord. And this accused person belongs to India, my lord. Dhupri, my lord. 2% attack the accused person, my lord. My lord, false allegation, my lord. Defective affair, my lord. My lord, kindly, my lord, allow me for the protection, my lord. I will appear, my lord, because the trial court face the trial, my lord.
Other 4 persons are appearing after being.
Yes, yes,
Li-
they are appearing, my lord. I have to appear, my lord. I am ready to appear, my lord.
Learned counsel for the petitioner learned additional PP. This is an application on the so and so. FIR was lodged at Dhubri PS on 25/5/24, alleging inter alia that the accused persons had forcefully entered the room of the informant and physically confined them and demanded a huge amount of money. Subsequently, after some negotiation, an amount of rupees 1,95,000 was paid to the bank account given by the
of Bangladesh, my lord. Deposit bank in Bangladesh, my lord, not Indian.
of Bangladesh provided by the accused persons. So, however, the government managed to escape from the clutches of the accused person and lodged the FIR. Para the case has ended in charge sheet, wherein the present petitioner has also been named. Para it is submitted on behalf of the petitioner that there is no specific allegation against him mentioned in the charge sheet, and the case is now pending for appearance, and it is apprehended that upon his appearance he would be remanded to custody. Is further submitted that the petitioner is desirous of facing the trial. Where it appears that 4 of the co-accused persons were arrested and were subsequently released on bail, and the case is currently pending for appearance of other co-accused persons who have been shown as absconders. Full stop. Having regard to the fact that there is no specific allegation against the present petitioner in the charge sheet, and that 4 of the co-accused persons, after being granted bail, have been appearing before the court below. comma, and also having regard to the interest of the trial, it is cancel it is deemed necessary to allow the prayer for pre-arrest bail. Accordingly, it is directed that the petition event of 1,002 sureties. Satisfaction of the arresting authorities court. Further directed that the petitioner shall appear before the which court? CJM?
SDGM S Dhubri.
Dhubri. Any date fixed? Next date?
Yes, my lord, 30 June. In
The
this
next
month.
date fixed, that is 30th of June 2026. And the section granted by this order shall become inoperative the event of failure of the petitioner to appear before the court on the said date. Comma, save and except for exceptional reasons. And allowed accordingly. If you don't appear, order goes. 30th, if you don't appear, this protection goes.
No problem. Obligation. Yes, sir.
It is also. I am preparing for the number 2. Password for the bail also.
Immediately after vacation money.
The prayer of learned counsel for the respondent number 2 and with the consent of the learned counsel for the petitioner lays the matter again on. Just give a date after vacation.
Obliged.
What's your decision expected to in bill?
67.
In this case, driving license was not valid at the time of
Available.
accident.
Yes.
In this case, the driving license was not valid. That's against our liability. No, we are insurance company.
You are for?
Respondent number 1, claimant.
But owner and driver?
Owner and driver, Lordship, will have to serve notice, Lordship.
Not yet served.
For admission, it has come for the first time.
Administration learned counsel for the appellant insurance company. Mr. So-and-so appears for the respondent number 1 stroke claimant. To notice, this come first time.
For admission.
Appeal has been preferred against the judgment in order dated so-and-so on the cause title. Notice to the respondents number 2 and 3, stepped by speed post with AD within 3 days. List again after vacation date.
Your lordship,
The petition is there, Lordship.
Is there.
appeal, generally appeal is admitted on, then the notice is issued. Your lordship is certifies.
Can admit also, no, then admitted, appeal is admitted.
Trial court record may also be called for, Lordship.
Is here call for the, I think oh no, it's not in this case. Call for the TCR. IA to IA to statutory deposit.
Your lordship,
Statutory deposit, we have already made 25,000, Lordship. And if Lordship directs, we are ready to deposit 50%, but that is subject to Lordship bond only. Is to release. Otherwise,
Subject to bond.
bond by the claimant
release,
that we
release
will-
may be made subject to bond.
Otherwise,
Indemnity
Lordship, we have no liability, that is our plea.
IA 912. Heard Mr. So-and-so. IA has been preferred. Taking stay of the operation of the impugned judgment and award dated so-and-so. It is submitted that rupees 25,000 has been already deposited as statutory deposit, and the appellant insurance company is ready to deposit 50% of the awarded amount. That is in addition to 25,000. Additionally, okay. Amount. Few of the above, the execution of the impugned judgment and award shall remain stayed subject to deposit of 50% of the awarded amount within a period of
4 weeks.
4 weeks from today. Full stop. Para, upon such deposit, the same respondent number 1 stroke claimant shall be allowed to withdraw the same subject to execution of suitable bond to the satisfaction of the. Where will you deposit, here or there?
Here. Here.
Of the registry. I stands disposed of accordingly.
Obliged, Lordship.
Oblige. Lordship, this appeal has been preferred by the claimant for enhancement of the awarded amount, Your Lordship.
Mr. So-and-so learned counsel for the length. This appeal has been preferred against the so-and-so. How many respondents are there?
Your Lordship, there are 3 respondents.
Notice to the respondents. We can admit today itself. Appeal is admitted. Call for the TCR, issue notice to the respondents. Steps by speed post AD within 3 days. List again after.
Highly obliged.
Number 9. Please note. So the FIR is a page number 18 and the relevant portion is page number 21, my lord.
Second prerogative, the company, the Rahul Kumar company has rented Escol Logistic Cold Storage located at Garapani, so and so mobile number for product storage and management. Vidyaji's responsibilities included selling companies' products in Gauhati and surrounding areas, providing invoices to the cold storage to obtain products and delivering the products to the buyers. Vidyajit in a planned conspiracy, Vidyajit is a petitioner over here, my lord, in a planned conspiracy colluded with the cold storage staff in between January 2025 to March 2025, stole and sold products approximately of 5 lakh rupees without issuing invoices, thereby embezzling the proceeds. In September 2025, an audit conducted by the company revealed that the products worth approximately of rupees 5 lakhs were missing from the cold storage. Upon thorough inquiry, Vidyajit admitted to the embezzling rupees 1 lakhs via a written email. After the matter came to the light, he initially promised to pay the full amount of rupees 5 lakhs, but later he engaged and began evading the issue. For the past week, the company repeatedly tried to contact Vidyajit, but his phone has been switched off. His family members inform us that he has been absconding for the past month, my lord. And in the second last paragraph, it was company has terminated Vidyajit's employment and ended its contract with Escol Logistics, my lord. Here I must submit, my lord. He was that time he was working as an assistant sales manager in that company, my lord, and he have the full knowledge of the stock position, my lord. The company have the full knowledge of the stock position through regular audits, my lord, and the audit used to in every month, my lord. Why the stock for January 2025 to March 2025 had their settled in the month of September 2025, my lord. And here they have alleged that regarding email, my lord. I have to take to your email at page number 24, my lord. The email that has been given by the accused petitioner, my lord. We have written here, page number 24, my lord. The email. As per the audit report, I am responsible for 22 CS cases, that is 1 kg chicken nugget stock. Rest of the stock, I am not responsible. No one mail from auditor, rest of the stock difference. I am only responsible for 1 kg chicken nuggets, 22 cases. Rest of the stock, not my knowledge, mother. Where does come from this? That it is admitted that he will give 5 lakhs for the entire stock, my lord. And it is correct that he is responsible for that only 1 kg chicken nuggets, that is 22 cases, my lord. Which was found to be damaged and stole, my lord, only for his negligence. And his phone was never switched off, and he has nothing has been done. It can be sent from the call records if required, my lord.
The email. Email which my learned friend is pointing out. Kindly produce the
Yes, we have. He says he is responsible for stock. What is the?
I'm pointing out in the top of the email, my lord. Never sent. Just Q. It's 24.
Queued.
It was queued. Then how they have alleged in the email? In the FIR itself, my lord.
The FIR email, that is different, man.
Oh, it is different. In the FIR itself.
FIR, they have not mentioned.
Which email they have given? Upon thorough inquiry, Vidyajit admitted to embezzling rupees 1 lakhs via a written email.
I pray for calling.
This does not appear to be the same email.
Yes.
Here, no 1 lakh or anything, nothing is mentioned here.
My lord, I am responsible for 1 kg chicken nuggets.
Yes, 1 kg.
Chicken nuggets, that is what rupees 70 something thousand.
22
cases
into 1 kg, 22 kgs.
In fact, that was never sent, my lord.
No, I have to take.
See, this is FIR is also of
Take
27/4.
2 years, my lord.
I can wait for some time then. PD. Province.
Can it be on 24th or 22nd? I don't know.
22nd only.
All right, ma'am.
Lordship, in this case, the insurance company has challenged the Lordship, impugned judgment and awarded it 16/12/2025 Lordship. In this, at the time of accident, there is a no valid DL Lordship. So accordingly, Lordship, DW, on behalf of the insurance company, DW have given deposed Lordship, but that was not considered by the Lordship.
Already heard so and so. This appeal has been preferred against the admit issue notice. Call for the TCR issue notice to the respondents. Steps by speed post ready within 3 days. 4.
IA Lordship for stay of the
This I think same heritage. You have deposited.
Lordship that if Lordship that for the DL Lordship, then the owner is liable for payment Lordship. DL is not able. At that time, the accident, there is a no DL Lordship.
Same case earlier also. You have to make a deposit.
Not to release Lordship.
Release can be, but execution of bond.
Okay.
Same order to deliver. 25,000 you have deposited? No.
Yes, Lordship. Already deposited 25.
Deposit 50%. Okay. Right to disposal.
This is an appeal filed by the insurance company against the quantum of error looks.
Hard answer. This is against ordered it. Is admitted. Call for the TCR. Notice to the response. Okay, order. IA is there.
I for the still also.
25,000 you have deposited.
Yes. Condition precedent looks.
And what about 50%?
We'll deposit 50% within 6 weeks. 6 weeks.
6 weeks. Yes.
May I please lord. We have filed this appeal, my lord, against the order on page 56, my lord.
So enhancement of
Cost.
huh? Enhancement.
No, my lord. The petition has been dismissed, my lord.
Hard counsel for the petition. This is preferred against so and so. Dismissing the claim of the petition. Bill is admitted. Call for the TCR. Stay order.
Flush.
Legal officer.
Lordship, this is an appeal against dismissal of the claim petition, my lord.
All right, same order.
Obliged, lord.
Steps by speed post steady.
Lordship. May I please, Lordship? Lordship, this is an MSc appeal, Lordship. Against the impending judgment and order dated 7/2/2026, passed in 25/8.
Dismiss.
2027, Lord.
Dismissal.
Dismiss, Lordship.
Same order.
Lordship, there is some IA.
IA for what?
After the there is an IA, Lordship. IA may be heard thereafter, Lordship.
IA is for what?
IA is
Your
for,
order has
Lordship,
been
for-
dismissed, huh?
For speedy disposal, Lordship. Much obliged, Lord.
May I please, your lordship? This is an application under section 483, your lordship. Petitioner was arrested on 25/5/2026, your lordship.
IA to order na
But your lordship, there was an accident that had taken place. FIR is at page 14, your lordship. This early morning, your lordship, while driving, the vehicle collided a man, your lordship. And on the basis of that, an FIR has been lodged, your lordship. So the pure accident, your lordship, he was arrested. But police has registered the case under section 109. 28 days behind bar, your lordship. And probably further custodial detention is not required, your lordship. Looking at the nature of the case, your lordship. Rather than that, your lordship, my only case is that this is an accident, your lordship. He has been under police custody for 4 days, thoroughly interrogated, your lordship. Everything has been seized, your lordship, vehicle, etc. And according to police, he has also admitted that there is a reckless driving on his part. And in view of that, probably, your lordship, he got his relation, your lordship, so far as further custody may not be required, your lordship. This is my humble submission, your lordship. Looking at the nature of incident, your lordship, and the custody period of detention he has undergone, your lordship. Rather than a case under 109, it would be a case under rash and negligence driving, your lordship. He has also mentioned, your lordship, in the forwarding report, your lordship. In round of arrest clause 2, the accused persons drove the vehicle rash and negligently. And he has surrendered to the police, your lordship, on being called, and your lordship from police arrested him thereafter. He has been cooperating, your lordship. Out of fear, your lordship, he may have, your lordship, played at the relevant point of time, your lordship. Otherwise, your lordship, mens rea was not there, your lordship.
After police remand, he was produced again.
Produced again and jail custody, your lordship.
That order is not here.
That is not there, but your lordship,
That is admitted, your worship.
No, we are not on that. We- Is
Content condition, my lord. Well admitted, my lord. Although, my lord, he was tested for
yeah,
the.
where from do you find it? It has come.
My lord, yes. My lord, he not only, my lord, hit a person, my lord, then it take him to 30-40 years. And he escaped, then that, my lord, to repair the car, so to make the accident, my lord. The car doesn't and person, my lord, who is RPF
Is
contacting him, my lord. But he was driving his vehicle. And there is no insurance also.
his brother-in-law's vehicle, your lordship. Only thing, your lordship.
After the accident, people panic and do a lot of things. That is true. But I think 109 is not there. Any material is there, such as him probably doesn't know even know him.
But he doesn't know.
Unknown person.
Unknown person, your lordship.
Heard Mr. Learned Counsel for petition. Mr. Additional PP. This is an application under so and so. As per contents of the FIR, the petitioner was driving his vehicle in a rash and negligent manner. And intentionally hit the victim while the victim was walking along with the informant. Here, Guri Supermarket Assembly area. Result of the state collision, the victim Noyan Das sustained severe injuries and had to be admitted into the ICU of GMCH. His condition is stated to be critical. It is submitted that the petitioner surrendered before the police. He was arrested and remanded to police custody and was thoroughly interrogated. Thereafter, he was remanded to judicial custody. And as of today, he has spent many
28 days.
28 days behind bars. There are learned additional PP. Upon perusal of the CD, fairly submits that there is no material to suggest that to suggest that it is intentional.
Yes.
That part only, that the petitioner intentionally hit the victim. Although the material reveals that the petitioner did not stop to help the victim and instead tried to But wash. What did he do after leaving? After
then-
hitting, what did he do? He went to service center.
My lord, that since it was an early morning incident, he went to a service center in Bamuni. Tried to
Next morning.
my lord, absconded, my lord. That, my lord, that is
At that part,
That part maybe-
he left without helping the petitioner. He fled from the scene. Only delay हो, huh?
check the victim.
Huh?
Check the victim 16-7.
But he fled the scene, we'll say, with that much detail. In regard to the said material, prima facie, the gradients of section 109 BNS may not be met. In the meantime, petitioner has spent 28 days in custody. In view of the above, the prayer for bail is allowed. 50,000 through securities.
Deeply obliged.
Satisfaction of learned Elaka Minister.
Lords. Deeply.
Cooperate with the investigation.
Please, your lordship. This is regular bail application, lordship. FIR will find lordship page number 12, lordship. The brief fact of the case is that lordship, the informant and one Afzal Ali, lordship, and they are doing business, lordship, of gold, lordship. In connection with the gold, lordship, they took 3 lakhs from the petitioner, lordship, but they could not provide the gold. And subsequently, on the date of occurrence, lordship, the informant, lordship, and Afzal Ali, they call him for providing gold, but instead of gold, lordship, they have returned some money, lordship, to the petitioner, that because they could not provide the gold, lordship. In connection with this, lordship, the informant, lordship, very tactfully and to lodge the FIR that stating that the petitioner is net some money from the informant, lordship. That is the allegation, lordship. And another aspect, lordship, the notice 48, lordship. You kindly come to page number 25, lordship. There is not served to the notice to the informant relatives or anything else, lordship. Even then, there is no any signature of the relatives or family members of the petitioner, lord. And subsequently, lordship, page number 26, lordship, that is, lordship, the WT message, that is not also served to the petitioner family, lordship. I am in custody, lordship, as on today 26 days, lordship. Otherwise, fact is totally different, very specifically.
owner of the scrapyard, Lordship. He is the scrap vendor, Lordship. On that day, Lordship, when police came, Lordship, on that day, I was there in the shop, Lordship. And police apprehended me on the basis of the statements of, Lordship, of the main accused, Lordship, that is Biswajit Baspur, and another person was also arrested, Lordship, Dhanjit Nath, Lordship. He has been enlarged on bail by, Lordship, by the court of JMFC, Lordship, Kamlup, Lordship. Lordship, the order is, the bail order is at page, Lordship, 17 onwards, Lordship.
What is your name?
Lordship, my name is Zahidul Islam, Lordship. I am the son of the owner of the scrap shop, Lordship. I have been arrested, Lordship. I was taken custody for 1 day, Lordship, police custody, Lordship. I have been thoroughly interrogated, Lordship. I have cooperated with the investigation, Lordship. And
You may be the same person involved in the theft of our AC copperware from District Judge Court.
Lordship, I am the son of the I am the son of the scrap vendor, Lordship. So, Lordship, what happened? Lordship, on the forwarding letter, Lordship, allegation is against me, Lordship, that is on page number 13, Lordship, point number 2, Lordship. May I read, Lordship? The apprehended accused person, namely Biswajit Baspur, led to the discovery of stolen AC copper pipe from the scrapyard of Zahidul Islam, so and so address, Lordship. The recover of stolen property Zahidul Islam frequently by broken copper pipes from accused Biswajit Baspur. That's broken, Lordship. So, as the Lordship, my father is a scrap vendor, Lordship. His business, Lordship, to buy broken items, Lordship, whatever the scrap item, Lordship. Lordship, I have been thoroughly interrogated. The investigation might have
They
completed.
know very well the source from where the copperwares are coming.
Lordship. Lordship, one of the co-accused, Lordship, Dhanjit Nath, Lordship, was allowed to go on bail, Lordship. The relevant part of the bail order, Lordship, is page 20, Lordship. Lordship, kindly.
You were arrested on the same day as Baspur.
Lordship. Another co-accused has been enlarged on bail, Lordship. Lordship.
Which one? Dhanjit Nath?
Yes, Lordship.
Who is he?
He also worked in our scrapyard, Lordship.
What can he do? He is not the owner.
Lordship, I am not the owner, Lordship. My father is the. He has the trade license, Lordship, at page number 15, Lordship. Page number 15, Lordship. Quran Ali, Lordship. My father's name is Quran Ali. He has a trade license, Lordship, to do the business, Lordship. So, Bonawat. Considering the length of detention, Lordship, I will cooperate with the investigation, Lordship, and I have been thoroughly interrogated, Lordship.
Yes, PP.
My lord, he is the owner of the cab godown, my lord.
Or son of the owner?
As per CD,
Lordship, I have annexed the trade license, Lordship. My father runs the shop, Lordship. On that day, I was there, Lordship. As my father went home, Lordship. We are from Nalbari, Lordship. So he went to native village on that day. When police came to investigate, Lordship, on that day I was there, Lordship, along with Dhanjit Nath, Lordship. Now Dhanjit Nath has already been enlarged on bail, Lordship.
Then tell your father to appear and make his statement that it is mine.
as per his statement, he along with his father runs the department.
He will appear,
It's
Lordship.
a family business. It may be in somebody's name. That's a different
Maybe.
thing.
I will cooperate with the investigation, Lordship. Any condition, Lordship. I have no criminal intelligence, Lordship. Prior, I have never been involved in any criminal activity, Lordship.
And he stated that he used to buy regularly.
Lordship, broken
this
item,
month.
Lordship. Broken item. Lordship, since a escape shop, Lordship. Broken items comes to our shop, Lordship. Our business is, Lordship.
These persons who steal these things, they cannot sell it randomly to anybody. They have a assured customer. That is where they go and sell. And it is all
Broken item,
known very
Lordship.
well to everybody.
Specifically, Lordship, stated, Lordship, broken copper pipes, Lordship.
Obviously, it will have to be broken if it is to be stolen from an AC.
The amount is also, Lordship, approximately 20,000, Lordship, the AC pipe, Lordship. Considering the length of detention and circumstances, Lordship, I may be allowed, Lordship. I
What
will
is the
cooperate, Lordship.
detention length?
20, as on today, Lordship, 22 days, Lordship. And since the co-accused has been enlarged on bail, Lordship, I may be,
He was
Lordship.
just a worker, my lord.
Any condition, Lordship. I have no any past criminal antecedents, Lordship. I will cooperate, Lordship. Any condition, Lordship. My father went, Lordship, and recorded his statements, Lordship, also. Investigation might have completed, Lordship, and custodian detention may not be required, Lordship.
Once we release you, next petition will be from this accused. The co-accused has been released.
He is the prime accused, Lordship. Regarding him, Lordship, earlier some cases is there, Lordship. He was involved, Lordship. Prime accused is involved in another case, Lordship. Any condition, Lordship, I will cooperate, Lordship. And I am, Lordship, only 20.
What condition? You will reveal the names of all your suppliers.
Lordship, what happened,
You can
Lordship?
put that condition.
Some broken items comes to our shop, Lordship. Being a bona fide purchaser and bona fide businessman, Lordship, we do this, Lordship. My father runs the shop, Lordship.
Very bona fide.
Very well know how these copper wires were
It has become a big nuisance for people.
nowadays.
Lordship, I am a 26-old boy, Lordship. Considering the length and Lordship, since the owner is my father, Lordship, and Lordship, only the prime accused stated that he sells broken pieces, Lordship.
Run it counsel for the petition and run. PP. There is an application under so and so. The allegation against the present petitioner is that he received certain stolen property that is stolen AC copper wires, which were allegedly stolen by co-accused Zahidul Islam.
Biswajit Baspor Lordship, who stolen Lordship. I am Zahidul Islam. I am the son of the
He
script.
was Zahidul Islam, so stolen by one Biswajit Baspor. From 6 Mile, Gauhati. Where it is submitted that the is the son of the owner of the scrapyard. Course of business kind of articles are bought by the scrapyard without knowing the fact that they may have been stolen. Learned PP on perusal of the PD submits that the as per statement available in the CD, the petitioner used to frequently buy broken copper pipes from the co-accused Biswajit Baspor. So the petitioner was arrested. Petitioner was arrested on 1/6/2026, and since then he has spent about 22 days in custody. It is also submitted that the petitioner is not the owner of the scrapyard. The is the owner and English has annexed the trade license regard having regard to the above as well as the period of detention. Therefore, bail is allowed. It is social securities satisfaction of the learned Ilaka magistrate. The provided that the conditions, okay.
I'm highly obliged, Lordship. May I please, Your Lords? This is an application under section 483. Your Lordship was pleased to call for the case diary. FIR is at page 17, Your Lordship. It was based on a certain statements made by the accused person who was an ex-MLA, Your Lordship. May I read, Your Lordship, page 17, Your Lordship?
I think we have already read it.
Lordship, on last occasion, and only thing, Your Lordship, I will not defend his statement. This statement is definitely, Your Lordship, offensive in nature, although no incident had taken place pursuant to that, Your Lordship. And it was in a private conversation, Your Lordship, he made said statement. But Your Lordship, I am only on his medical ground, Your Lordship has already perused it. Only one document, Your Lordship, I would like to place, Your Lordship. That is the report of the medical officer that Your Lordship will find it at page 40, Your Lordship. So there is a medical board, Your Lordship, constituted. "29 days behind bar, Your Lordship. Probably. Page 40, Your Lordship will find, Your Lordship.
However, the patient continues to report persistent low back pain with associated lower limb weaknesses despite ongoing evaluation and treatment. In view of these persisting symptoms and further assessment of the underlying neurological and spinal conditions, specialist consultation in Department of Neurology and Neurology at Gauhati Medical College and Hospital is considered appropriate for expert opinion and further management, Your Lordship. That is there. And the learned trial court also recorded at page 35, Your Lordship. Patient, the superintendent of district jail Dhuburi has forwarded the medical report of accused so-and-so and his examination conducted by board comprising of 6 experts related to medicine. From the medical report, it appears that patient, that is the accused, is not physically fit to do any day-to-day activity and cannot work without support, but he is mentally stable. The report clearly suggests that accused is suffering from various illness. There is a clear finding by the learned trial court also, Your Lordship. And section 480, Your Lordship knows very well, Your Lordship, has made an exception for sick and infirm people, Your Lordship, along with others, Your Lordship, so far as bail is concerned, Your Lordship. And Your Lordship, that has also been settled by the Honorable Apex Court in various judgments, Your Lordship. Otherwise, Your Lordship, 152 is the section they have brought in, Your Lordship. In my humble submission, Your Lordship, probably 152 ingredients are not there so far as this case is concerned, Your Lordship.
Yes, what have you got, PP?
My lord, CD received, my lord. Regarding, my lord, this health condition, my lord, the learned lower court has already observed, my lord. But team has already examined him, my lord. That observations are there, my lord. As it may, my lord, going to the report, that is not so has already taken a view regarding a health condition. For my lord, this present case is concerned. Yes, my lord, here it was shared through Facebook. The URL, my lord, that URL user is yet to be identified, my lord. And police has also that has been sent to my lord, Bongaigaon FSL, my lord. That report has yet. Secondly, my lord, previously also he was, my lord, use of, my lord, certain criminal cases are, my lord, also raised. One is Gorupur PS case number 546, 2015, and that has been charge-sheeted, my lord. And another is, my lord, Bilasipara PS case number 583, 2012, my lord. That has also been charge-sheeted, my lord. My lord, there was allegation of assaulting, my lord, civil servant by this accused also. So it going by his, my lord, previous history, my lord. He is a known troublemaker, my lord.
May I submit, Your Lordship? So far as Your Lordship, other cases are concerned, already search sheet has been submitted. There is no allegation that in those cases I have tried to influence the witnesses, Your Lordship. That is not there. I am cooperating with the trial. Trial is going on, not yet convicted, Your Lordship. Now, had that been the case, Your Lordship, that in other 2 cases I have tried to influence the witnesses, Your Lordship, then matter would have been different, Your Lordship. It's an independent case, Your Lordship. Here, the material, what are the materials and whether custodial detention is required or not. That's the only issue, Your Lordship. And Your Lordship, in view of his medical condition, Your Lordship, these statements he have made, Your Lordship, absolutely, Your Lordship, condemnable, Your Lordship. Such statements, Your Lordship, we cannot, Your Lordship, in a democratic society, one cannot make that to a. And the only thing, Your Lordship, that when a person is, Your Lordship, not in a position to work also, Your Lordship, in such a situations, whether bail can be granted or not, Your Lordship. And that too, when section 480 statute has specifically provided the granting of bail for sick and infirm persons.
So it will examine the reports and everything.
Lots.
Also with the CD also.
Lots. Deeply utilized, Your Lordship.
26 also someone is appearing, I think. It is connected with 26.
No, your lordship, not connected.
Huh?
No, not done.
This is 55.
55.
Oh, this is 55.
Deeply obliged, your lordship.
My lord, it's a very small case, my lord. Yeah, actually, there was a love affair between the petitioner and informant's daughter. That was in the year 2021, my lord. At that time, petitioner age was near about 23 years, my lord. And then after a few months, she has expressed a desire that she is no longer want to continue their affair, my lord. And then she disclosed that he being the poor, my lord. So he immediately went to Bangalore. Still now he is working there only, my lord. And after going there, my lord, when this case was filed, the summons issued, warrant issued, and everything, PNA and everything, he was not knowing everything. And my lord, the police, they have gone to his house also, my lord. They have not found him. They have asked their neighbors also, my lord. They all have disclosed the same thing, that from last 3-4 years, the petitioner is staying in Bangalore, my lord. If they have put some extra effort of knowing about the address of this petitioner in Bangalore, my lord, they could have served the summons or warrant upon the petitioner, my lord. So he is not knowing anything. And my lord, another thing is that if suppose there is a rule also, my lord, if suppose before issuing of summons warrant, if a person for some personal reason or of some because of professional reason, if he is out of station, my lord, then it cannot be said that he is trying to evade his arrest or trying to not want to want to take the summons or warrant, my lord. So my lord, 29/6 is the next date, my lord. So I'm praying for the bail only on that ground, my lord, as he was not aware of anything, my lord. And they have also not put any effort to know about their address, whereas they have investigated their entire village, my lord. And entire village, every people have said that he is out of station for last 3-4 years. He's in Bangalore. He's working there. He's working in a company there, my lord. Only on that ground, my lord. 29/6 is the next date, my lord. And my lord, in second last page of that TCR, my lord, it is clearly written by the police station that from last 3-4 years he is staying in Bangalore, my lord. He have not come to this place. Still there in Bangalore, my lord. But in 29/6 as next date, he will come, my lord.
Yes, PP.
I could not go through the TC.
There is nothing as such, actually. 29/6 is the next date, my lord.
Actually not taken. She was family arrived at Badarpur police station, railway station, and then her back. He was in the process of taking her to Bangalore.
And in police station also, they have not seen this petitioner, my lord. They have seen some other person with that girl, my lord. I was never in the scene, my lord. I was never. Since she had disclosed that she is not interested in me, at that time I was 23 years, I left her. And since that date till date, my lord, I have never disturbed her. I have never disturbed her. This was only related with love affair and nothing else is there, my lord. I have never disturbed her.
Okay, we'll see. So.
That's fine.
Please, my lord. My lord, in this case, both the petitioners are husband and wife, my lord. Petitioner number 1 is the husband and petitioner number 2 is the wife, my lord. Petitioner number 2 wife already in interim, my lord. Only she appeared before the IO, my lord, and recorded a statement. My lord, in this case, only allegation is against the petitioner number, main allegation against the petitioner number 1, my lord, is that, my lord, he, my lord, struck the husband of the informant with a dao, my lord. That is the allegation, my lord. Only thing is that, my lord, whether it's come under the definition of the grievous hurt or not, my lord. As my lord, remaining sections all are bailable, my lord, except the section 118, my lord, subsection 2, my lord. That is the non-bailable section, my lord.
My lord, as per the
Injuries? The hard to answer an application number. Dated 18/5/26. Okay. Para 1, 2. TDS called for has been received. Although the allegation regarding causing of grievous injury by a machete from the medical report indicates only simple injury. This by order dated 18/5/2026 had granted interim pre-arrest bail to the petitioner number 2. Having regard to the of the injuries, the petitioner number 1, Jayanta Kolita, is directed to be released on bail of 1,000 with a share of like amount, the satisfaction of the authority. The event of his arrest in connection with Chualco CPS case number 23 of 26. The order of interim bail in respect of petitioner number 18/5/2026 is also hereby made absolute. The following conditions which shall be applicable to both of the petitioners. 2 and 3, that order.
Obliged, my lord.
Yeah, please, your lordship. Anticipated bail application, lordship. PD and the injury report was called for in the matter.
my lord, here charges submitted, my lord. That's information.
In this, no. I will appear, lordship, with some protect.
What is the section?
Section involved.
POCSO?
No, lordship, no POSCO. 118 and voluntarily wrongful restraint and voluntary causing hurt and grievous hurt and theft, Lordship.
First, it was submitted under
All are
section.
magistrate tribal.
Yes, all are
First,
magistrate
it's submitted under section 61, 191, 3,
Any
126.
sessions tribal cases? No. Huh?
section 51.
What is the main offense?
Lordship, as per the FIR, the main offense is that Lordship will get the FIR.
As per charge sheet.
Charge
Now
sheet
what
on
is
main offense.
As per first sheet, my lord, 191 subsection 3, 126 subsection 2, and 117.
So these are all magistrate tribal.
Lordship. We will appear, Lordship, with some protection.
Hard learned counsel for the petitioner and learned. Hard learned counsel for respondent number 2. It is submitted that CS has already been submitted. This case by CS number.
Case number 101, public 2026.
Under section.
Section 61, 191 subsection 3, 126 subsection 117 BN.
Learned counsel for the petitioner submits that the petitioner shall appear before the learned trial court and apply for regular bail. Accordingly, the present AB is disposed of. Observation that the event of the petitioner appearing before the learned trial court and applying for bail is the same shall be considered as per law. Till then, provided that the petitioner event of his arrest shall be released on bail of rupees. The arresting authority. Provided that the
God bless you, Lordship.
within a period of 10 days.
Lordship. Can it be 15 days, Lordship?
Action granted shall remain in force till the said period of 15 days.
God bless.
Happy as a Lordship. Lordship, this is pre-arrest bail application, Lordship. Case there was called for. FIR at phase 9, Lordship. The action is under section 331 and 64, Lordship.
The 183 indicated the accused person, my lord, but there is a statement. Yes, my lord. That may be kindly perused.
Learned counsel for the petitioner. An additional PP. This is an application under. As per the allegation contained in the FIR lodged by the informant victim, the petitioner entered into her house forcefully entered into her house and committed sexual intercourse with her against her will. The absence of her husband. CDS call for has been received. Perusal of the statement of the brother-in-law of the victim herself, it appears that the exchange was consensual in nature. Having regard to the same, the prayer for bail is allowed. Send back the CD.
Right.
The accused person. Then, my lord, this theory should have been placed by the police that there was mutual marpit between the deceased and the accused persons, my lord. And they procured injuries, the accused persons, because of that mutual marpit. Have I made my position clear, my lord? Otherwise, kindly see the language, with all respect, in the forwarding report, page 20, my lord. First, second, third, fourth paragraph, my lord.
In your case?
In my case, my lord, I'm sorry.
BA 1627.
BA 1627, my lord. Constitution.
Page?
Page 20, my lord, with all respect, my lord. My lord, in head note, my lord, marks of injury on the body of the accused persons. Lordship, I have seen, my lord. Page 20, first, second, third, fourth paragraph, my lord.
Yes.
Kindly I read it, my lord, with all respect, my lord. It is respectfully brought to the notice of the Honorable Court that during the physical examination of both the accused person, at the time of their being taken into custody, certain marks of injury were observed on their bodies, especially on the buttocks, legs, and hands. These injuries are noted herein in discharge of mandatory statutory constitutional obligation cast upon the investigating officer. It is unequivocally submitted that the said injuries have not been caused by the police at any stage. Goodness gracious. Then, my lord, with all respect, they should have brought in the theory that there was mutual marpit. As a result of the mutual marpit, the deceased was dead, then thereafter his body was put into the tank, my lord. Have I made my position clear, my lord? How can they do like this, my lord? So that they have to confess that they killed him, my lord. This is the language, my lord. And 21 days, when 21 days they do not, 23 days they do not find out anything, my lord. They will never find out anything, at least from these two people, my lord. And these Himalaya reports, what more will come? FSL, so as to prolong prosecution part, my lord, their argument that, my lord, it will prove what? Is it a death by administering poison, my lord? No, they have categorically stated one head injury, instrument not found. After 23 days, with all respect, my lord, and my friend has rightly said, my lord, government officials, petty of my officials, my lord, with all respect, my lord. And the FIR does not disclose anything, my lord. All were created story, my lord. Unknown person, specific allegation, my lord, after 23 days. And if the FSL comes, FSL will not pinpoint who, if there is, my lord, with all respect, injury was inflicted by somebody, that would never come.
But it appears that is homicidal from the forwarding report itself.
Forwarding report as stated by the police, because there was an injury, my lord.
It is reference to the postmortem report.
Yeah, lordship is correct, my lord. But even in that event, my lord, with all respect, my lord, my lord, Assam police cannot begin investigation, arrest people and begin investigation, my lord. After completing investigation, I'm not meaning charge sitting, my lord. What I'm meaning, my lord, definite clues are to be found out as to their involvement. They arrest, bash up, try to make them apparently, my lord, confess, apparently this paragraph, my lord. Otherwise, I would not have placed it, my lord. And after 23 days, if this is the stage of investigation, my lord, they're waiting for the FSL report. What FSL will disclose, my lord? Their involvement? Culpability? No.
How did the offense come to light first?
Hello, we informed the police when we discovered our colleague lying in the ground. He has fallen from the second floor of the water treatment plant because those valves which he closed, probably he has fallen from that and fall into the ground floor. And a lot of noise, my lord. I had personally, I had asked him that what has happened. They said that so much of noise, even if a person falls, we will not hear. It was only when we went the round of the checking of the valves and all, then we saw our colleague lying in the ground. And
His body was found beneath a rotating circular metallic component inside a sealed underground tank.
No, my lord. I have the photographs of the place of occurrence. My lord, what has happened? He has fallen from the down, and in that area there is a circular thing. He has fallen inside that circular. My lord, I can show that photograph in the iPad. My lord, it's not that, my lord. They are trying to make out of a story out of nothing, and the learned judge of the trial court, out of the production court, has when we brought to them that the judge has, upon being specifically queried by the court, the accused person submitted that they had sustained injury on different parts of their bodies, particularly on their buttocks, posterior region, allegedly as a result of assault and torture inflicted by the police in custody. They had, we even said that they had inserted the stick into our...
Exactly. That is, my lord, that has been told to my client also, my lord. Something was inserted through their anus, my lord.
The learned judge could not like...
And that is why police has stated in the forwarding report that, my lord, in anus there were injuries. If the anus, my lord, there are two parts of the story. Either beaten up by the police or mutual marpit between the deceased and the accused. After writing this, this is travesty of truth, my lord. How can they write, my lord? Kindly see, I am repeating these lines. And how they end it, my lord. With all respect, my lord. Just repeat not for the sake of repetition, so that the truth comes out, my lord. It is respectfully brought to the notice of the Honorable Court that during the physical examination of both the accused person, at the time of their being taken into custody, certain marks of injury were observed on their, specifically on the buttocks, legs, hands. These injuries are noted herein in discharge of the... Have I made my position clear, my lord? If there are injuries on the body of the accused, what police should have investigated, my lord? That there was mutual marpit. Were they drunk? No. My accused does not drink, his accused does not drink. I have asked specifically that whether it is a drunken brawl. No.
My lord, the whole area was covered under CCTV. If there was some foul play by any of this accused person, well, that should have been covered in the CCTV. That is not the day.
CCTV, they see one part of the story, but they don't see if there was mutual marpit or not, my lord.
But whatever be it, my lord, for 23 days we are in custody, assaulted brutally in police custody, government servant, 48 hours detention, placed under suspension.
Every day we appear, my lord.
And they are all local boys walking in a grade 4 post. All three were grade 4 posts. And we don't want to impute any motive disease and all at this stage, because that will be a matter of trial.
How many persons were arrested?
Two, my lord.
3 persons were walking. That's why they said
one dead.
Last scene.
Last scene.
Also, whether the compound was properly secured. They said that in the backside anybody can come, but that is nobody's story. Actually, the real...
So at the relevant time, only 3 were present, including the deceased.
Yes, sir.
Secured compound, 3 were walking in different...
My lord, 3 were employees of that particular
water treatment.
Gauhati water treatment plant, my lord. All 3 were employees.
Satpukri, my lord. Navagraha Hill stop. Only on suspicion, my lord, they have been detained. And the Honorable Court has also recorded that when the IO has said that no, we did not torture. And the surprisingly, doctor who examined the
Yes,
court
he
can
should be
say,
hold up, my lord.
doctor says that no external injury. seen,
Injury,
my
my
lord.
lord.
This
He
is
should be hold up, my lord.
your my lord has probably seen those forwarding reports in the court below. Doctors also, my lord, in spite of all these injuries, they give a report saying that no external injuries.
And my lord, kindly see violation of 23, their language, police. After all, it's my lord, transparent, my lord, criminal justice delivery system, democracy. I'm reading their forwarding report. Kindly see, can they write like this, my lord? My lord, with all respect, page 19, non-cooperation of accused person in investigation. Article 23, my lord. Straight away violation. Kindly see. This should be the language of the police or not? Lordship will decide. 23, my lord, article. It is most, Lordship may have found, my lord. Page 19, my lord.
Yes, that we have seen.
My lord, kindly this line, it is most respectfully submitted that both the accused persons have completely refused to cooperate at the investigation. That means you put something in my anus and say that I have killed him. Should I do that? And what is 23, my lord, with all respect, my lord? Article 23 of the Indian Constitution is a fundamental right that provides protection against self-incrimination. It states, no person accused of any offense shall be compelled to be a witness against himself. You make me a witness, this is your language and tenor. On that ground itself, my lord, possibly, my lord. And my lord, keeping us there, FSL will come. FSL will disclose what, my lord? It will not disclose anything. It's not a case by administering poison, my lord. And every day we appear, my lord.
Just to add one line to my friend's submission. My lord, this self-incrimination exception is there under section 25 and 27 of the Evidence Act. If it is leading to the discovery of some murder weapon.
Absolutely.
There is nothing to lead. Nothing, madam. And we have seen the photograph of the place of occurrence, which was clicked in the mobile. The body was lying after falling on a rod, and then there was a circular thing. Inside is the tank. And because of this incident, my lord, the entire water supply has to be disrupted for 2 days.
Oh, no water was supplied, my lord, because somebody was dead.
Done. And we are the person, my lord, who informed the police about the death of our colleague. And now, my lord, we have been tortured in police custody, my lord. The police behaves in this way, my lord. My respectful submission that your lordship may kindly consider on any terms and condition, my lord. We are not going to escort my local boys. Working in a grade 4 post, families are dependent on them.
Pass over the CD. Anything else to submit?
Yeah. My lord, any injury or my lord, we cannot.
Mr. Opinion person, Mr. Opinion, কোনটো পেজত আছে?
Where is it? Where is the CCTV footage?
It is in.
He is correct, my lord. Only one thing, my lord, magistrate, learned magistrate below, my lord, judicial authority, my lord, just for the sake of placing it, my lord, 22, order of the learned magistrate dated 35/26, when they were produced, second paragraph. Upon being specifically queried by the court, this is the procedure, my lord. As per BNSS, the accused person submitted that they had sustained injuries on different parts of their bodies, particularly on their buttocks posterior region, allegedly as a result of assault and torture inflicted by the police during custody. What more is needed, my lord?
And that we have understood, but what is your submission that because they were assaulted by the police, they are entitled to bail?
No, I'm not saying. I'll never say that.
No, he was stressing so much on that.
No.
That aspect has been already taken care of.
My lord,
till
what
now.
police is intending, that, my lord, they are to find material and arrest, my lord. What they have done, they have arrested, they have developed a story in their mind that because there were 3 persons, he was killed by these 2, and they should make confessional statements, my lord. And hence, injury was inflicted, my lord. So,
there, I think the question of What was the nature of that place? Was it a secured place? Did others have access to that? All those questions will come in.
And if the Lordship would kindly see that 100% there is, my lord, and the Lordship would see the CCTV footage. From backside, from behind, my lord, that place, anybody can enter, my lord, with all respect, my lord.
With utmost respect. Not a case where an outsider has killed.
Absolutely
our
not.
colleague. He has died due to an accidental death. I can show all the photographs of the deceased in the iPad, where he was lying on the ground after falling from the second floor. Why would we impute a theory that someone else from outside has come and killed our colleague? It may be an accident, and so much of noise inside that water treatment plant. Immediately, they did not notice. When they went on their round, they only noticed that that our colleague has died by falling on the ground.
No, the problem here is that evidently there must be a postmortem report. Since postmortem was conducted, there must be a postmortem report. And it appears in the forwarding report that with reference to the postmortem report, it's a homicidal death.
And
So that is the problem with your theory.
Yes. Problem is that this forwarding is generated by AI. That's the main problem, because AI writes all sorts of things without.
Nowadays, authorities also, my lord, they quote apex court authorities. We have never seen in my lifetime, my lord.
And last seen theory, my lord, your lordship will see proximity is not always the criteria for last seen theory. One may be in proximity, but that doesn't mean that just because I have the last seen theory, proximity, that's why a person is involved in the offense. This is the problem, because AI, because immediately on the day of the forwarding, probably the postmortem report never comes, because postmortem was done on the day when we forwarded, or probably the doctor may say that you can also explore the angle of homicide, but that has not come out during the investigation. By beating a person, you cannot make a confession of homicide. And our case is that it is not that outside person has come and killed, especially my case. It's not. He has died an accidental death inside the water treatment plant. And they had enough time for all these 23 days to interrogate us, to sustain for intense custodial detention. So I respectfully submit that, being the in evidence of this area, government servant, that's why I am repeatedly harping on those points, that my release from custody will not hamper in the investigation. That your lordship can always take care of in this type of cases. We have sympathy for the bereaved family, because the informant is has only stated on hearsay evidence. She have any direct knowledge of the incident. But if it is a case of husband and wife sleeping in the same room and the wife dies under the mysterious circumstances, then the husband has to give an explanation. This is a place where water treatment plant, big machines are working. The person was walking in the upper floor, fell down while turning the knob, maybe. And if there was some foul play, or if there was some altercation, argument, free fight, then, my lord, those would have been caught on CCTV. Where is the evidence to prima facie to ask for a further custodial detention, my lord? They were given sufficient time, taken into custody, violated the DK Basu's judgment. What more they require, my lord, at the investigation? That's why we are humbly praying before your lordship will consider our release from custody at this stage, and your lordship will put up appropriate conditions, my lord, that will not try. There's no question of hampering or tampering with the evidence, because all the evidence that is there has already been collected, my lord.
Yes, like.
But another that CCTV footage, lordship would see, CCTV footage will not definitely catch hold of everything, my lord. Entire spectrum, my lord. One part it would record, one part it would not record. So police has never stated a single line that there was mutual market between that three, my lord. With all respect, my lord.
And if there was some CCTV footage, there is no allegation that we have tried to tamper with the CCTV recordings. We have put the CCTV into off. Those are not there, my lord.
Lordship would kindly have a look at it.
We are deeply obliged for giving us a
Obliged, madam.
May I please your lordship?
Yes.
Lordship, this is a charge-sheeted matter, my lordship. Lordship, the accused herein, the petitioner, he has received the notice from the Honorable Court of Azizam Koliabor, my lordship. My lordship, the sections in which the charge sheet is submitted, my lordship, out of which, my lordship, the sections are sessions tribal in offence, sessions tribal offence, my lordship. So, my lordship, the notice has been received from the Honorable Court of Judicial Magistrate First Class Azizam Koliabor, my lordship. So, my lordship, here the petitioner herein is appearing on his appearance. My lordship, forwarding from the Honorable Court at Koliabo to Nagaon, my lordship, to the committal court, my lordship, he will be in judicial custody. And by the context of the FIR, my lordship, though the name of the petitioner is stated, by the context of the FIR, from the seizures made and from the house search, my lordship, it was received from the fake currency. It is a case of fake currency, my lordship, in which the informant who belongs to Nagaland was cheated, my lordship. And in this case, my lordship, the search was conducted and it was all recovered from the one person named Abul Kalam. That person went in his own personal car and has delivered the amount, and that car is also seized, my lordship. And from the house of another accused, Abul Kalam, as per the search memo also, my lordship, all the seizure at Annexure 3, page 18, my lordship, all the seizures were made, my lordship. My lordship, with regard to the petitioner, my lordship, he is ready to face the trial with any stringent conditions, my lordship. Annexure 1, page 10 was the FIR, my lordship, and thereafter subsequently the charge sheet is filed, which is at page 26. And Annexure 3, page 18 is the seizure from all the everything was seized from the accused person who went personally to the informant in his own car, and that car is also seized, my lordship.
What was called for such? It is charge sheeted case. TCR was not called for.
My lordship, it has wrongly come in the column of bail hearing.
Then we have to call for the TCR then.
Can it be on the last?
If it comes, we'll take 26th. This charge sheeted case and call for the scanned copy of the TCR along with text.
Bless my lordship.
Very pleased, your lordship. Lordship, last time call for that DCR, my lordship. Charge case, my lordship, the FIR is page 14 and charge sheet page 19 and 20, my lordship. Main allegation against the accused number 1, my lordship, 2021 case, my lordship. And after 2 months of languishing in jail, accused number 1 got bail, my lordship. And the other accused 3, 4, 5, 6, they also got recently anticipatory bail by the learned Session Judge Dubri, my lordship. And in the case diary, my lordship, they learned Session Judge observed there are some incriminating material against the present petitioner, my lordship. But my humble submission before your lordship is that as because charge sheet is filed and it has been long pending cases and investigation has been completed and the learned the petitioners are already ready to appear before the trial court, my lordship, they want to face the trial. And the main accused already got bail after spending 2 months in the jail, my lord. And accused.
Why should you not spend 2 months?
My lord.
This is AB, isn't it?
Yes, my lordship.
You also go through the same route.
My
2
lordship,
months in
the
jail.
specific allegation against the accused number 1 only, and no overt act and covert act mentioned to this particular petitioners, my lordship. And this thing also reflected in the charge sheet also. The main allegation against the accused number 1, my lordship. While drawing the water in the paddy field, in the drain, there some altercation happened, my lordship. In that altercation, the victim fell down and hand was broken. Thereafter, hand was recovered. That, my lordship. I have the photocopy also, my lordship, that particular victims. That's my humble submission is that, my lordship, kindly allow them to enlarge on bail and let them cooperate with the trial proceeding. I will not hamper and temper an evidence. I'll completely cooperate with the investigation, my lordship. At that point in time, the particular occurrence happened, my lordship. My age was petitioner number 1, accused of 15 years, my lordship. I was in school, my lordship. And the accused number 2 was 18 years, my lordship. 2021 incidents, my lordship. So that's my humble submission before your lordship. Kindly grant me 3 years bail. I will appear before the. And my lordship, the charge sheet is 19 and 20, my lordship. Charge also mainly
Saidul, you were Saidul.
my lordship, petitioners, two petitioners, my lordship, Saidul Islam and Saiful Haq, my lordship. And Robiul Haq is the main accused number one, my with whom the altercation mainly happened, my lordship. Thereafter, as per the FR allegation that we all went there, but the main specific that particular offense committed by the accused number one. Though in the FR it is said that I were also there, my lordship. And the other co-accused also recently 13/02/2026, learned session just gave them the PRS bail, my lordship. As far as my part is concerned,
Yours was refused after perusing the case
yes,
diary and
lordship,
finding
my lordship,
material
I
against
accepted.
you.
I admitted the fact that they reflected that some incriminating material against me, my lordship. I stated myself. My humble submission is that my lordship has because
So if that material is there, why should we take a different view from the session judge?
my lordship, that's because Sashit is completed, investigation is complete. That's my humble prayer.
It was already completed when that matter order of rejection was passed.
My lordship, the bail order is my lordship 23.
Yes, it is charge sheet number so and so is reflected in that order.
My lordship.
21.
Yes, my
Yes, and you have been and you have come here now.
kindly consider. Allegation is mainly my lordship against accused number one, my lordship. The FIR also and the charge sheet also. An investigation is completed, my lordship, 2021, my lord. That particular offense committed by the accused number one, it is mentioned in the FIR, my lord.
By absconding for 5 years and
My lordship,
now
the
coming.
offense are
you
non-bailable,
cannot-
my lordship. I would have been arrested if I would have cooperated. So kindly consider, my lordship may put any restriction, any condition at severe, my lordship.
You can say in every case.
Both are young boy, my lordship. Lordship may put any condition, my lord.
Summons was issued several times to you, but you did not appear then.
My lord.
There is no explanation why you did not approach earlier. For delaying the trial for 5 years, now you want to come in.
Where my lordship investigation is
What?
custodial interrogation may not be necessary, my lordship. As we
Custodial interrogation,
my lord.
or charge sheet.
I should kindly consider your
That
lordship may
this kind of conduct cannot be encouraged.
kindly put any restriction, my lordship. Kindly enlarge.
Everywhere come back after 10 years and say, Heard learned counsel for the petition. There is an so an application under for accused persons of petitioners, namely Saiful Haq and Saidul Haq. Connection with so and so. Twenty-three last para facts. To the record appears that the present petitioners were absconding during the period of investigation. The charge sheet of the case was submitted on 30/11/2021. Thereafter, summons was issued to the petitioners, but they never responded to the same. It is in the present year, that is 2026, that the petitioners first approached the learned session judge. Application for free arrest bail, which was rejected upon perusing the material available in the CD. The TCR has been perusal of the material herein. Involvement of the present petitioners are very much present. Learned counsel for the petitioner has the co-accused persons have been granted bail, and at present there is no necessity of custodial interrogation of the petitioner. There are from examination of the circumstances of the case, it appears that the petitioners have avoided the process of the law for 5 years, and there is no explanation as to why they did not approach the court for relief here. due to non-appearance of the petitioners, the trial has been inordinately delayed. We are considering the above as well as the material available against the petitioners. The prayer for PRS bail stands rejected. The petition stands dismissed.
Table of placement.
36.
Here is an interim bail matter. She has appeared and recorded in statement, and IO required that his licensed firearms should be deposited. That has been deposited. She's the memo has been prepared, Your Lordship.
There are two FIRs.
Cross affairs, madam.
Yes. Hmm? No, I'm not getting you. Please speak a little louder.
He's been recorded, my lord.
Hmm. You are for? So both sides have been granted interim bail. What is the medical report?
Report, my lord. The report is not there, my lord. Some, my lord, treatment is. Put my lord not there. Lots of cases pending. This incident happened. I'm affair.
But without the injury report, how is it possible? We at least have to come to a finding of whether any grievous injury has caused.
Yeah.
He was treated in a private hospital.
Yes.
There must be some report of that hospital. Case is registered under which section?
The only non-bailable section, my lord, is 118(2).
So what is the material under 118(2) that we need to know? You were supposed to be hit on the head, according to you. So no significant intracranial findings present in NCCT of the head. So if there is some fracture, it would have been indicated in the CT scan. Scalp swelling is there, scalp swelling.
The last occasion also, my learned friend attempted to show a video, your lordship. The honorable court did not take it because a video, unverified video showing it on an iPad during a bail proceedings. This is here, we are not. Oh, my learned friend was granted liberty to file it, bring it on record by an affidavit. What I'm saying is that this attempt to show a video during court proceedings perhaps prejudice your lordship. My lordship is well aware.
Suppose your video, what will your video show? Video will show that he hit you. Blood may also come out. But ultimately, in order to amount to a grievous injury, there has to be a fracture. But where is there any report showing that? That doesn't mean anything. We cannot act on your instructions. It has to be here. No amount of statement can convert a simple injury into a grievous injury. That is why we are repeatedly asking what is the medical report with regard to the injury. All the other sections are bailable, only one non-bailable section is there and there is no material to support that section. Regardless of the fact whether he has 5 or 10 cases against him pending, what alternative does the court have? Mr. Particular counsel for the petitioner. Learned additional PP also heard, so and so for the. Go to order dated 10/6/26, para 1, 2, 3. The CD as called for has been received. Pursuant to interim protection granted by this court by order dated 10/6/26, the petitioner appeared before the IO and his statement has been recorded. The CD as called for has been received. Perusal of the medical documents in respect of the victim, more particularly the capital NCCT scan of the brain dated 6/6/26 appears that no grievous injury has been found in the head of the victim, although the allegation is that the petitioner had hit the victim on his head with the butt of his pistol. Full stop. Therefore, prima facie, it appears that the main ingredient of section 118 subsection 2 BNS not attracted. The rest of the sections are available. In regard to the above, the prayer for bail is allowed. The order of interim bail dated 10/6/26 is hereby and absolute subject to the same conditions as may be applicable as of today. Yes, yes, we have recorded your name.
Pistol license arm has been seized. Already deposited.
I think it has been seized already.
Already seized.
No, that is what it shows. This is the seizure list. It is already there. No, what condition? Is it again? Huh? It will be kept in seized condition until order is passed by the competent court for its jimma or whatever. How can we say? Further provided that the petitioner shall not try to contact or intimidate the victim or the witnesses in any manner.
Deeply obliged.
It pleases your lordship. Lordship, it's an IA in an MSc appeal. IA for condonation of delay, your lord.
How many days?
388 days, your lordship.
By insurance company?
Your lordship.
No, by claimant. Who?
Oh,
You are for the
driver. Owner and driver.
owner and driver.
Yes, your
You
lordship.
have been imposed with the liability.
Yes, your lordship. We have,
You did not have insurance.
lordship, we have engaged advocate in the MSc case, but they have filed the written statement, but they have not pursued the matter. And when asked by the appellant in this case, they were told that all we have explained the delay in paragraph number 7 and 8, your lordship.
Of the judgment, it was delivered on 19th.
2002?
Right, para 6. around. No explanation, what should be 7. But the how many days? Thereafter, come to know from what is. Yes, all are my lord, that the. Yes, we are place starting. 9124. Then there is a static financial condition for. No proper explanation.
These are all explanations only, your lordship.
Only 360 for more than 60, no explanation. And lordship.
What is the amount?
70,000. They did not even a tribunal below. The part of the concept cannot be grounds to follow long and inordinate. As the litigant owns the DCC of his own, right? To be equal to vigilant about the litigation. Additional has been. The honorable Supreme Court are not supposed to liberalize. Justice. Obligation given. On the ground. Fancy food. Paragraph 9 of the judgment. Asian has the only expression questioning for the period and the exception is that it engages and counsel and ask statement are also to the progress of the case, but he has not. He owes. Then on the head of the
Your Lordship, here we have filed the written statement. After that, the perusal of the case was absent and we are laymen, Your Lordship. Once we approached the advocate, we only communicate with the advocate, Your Lordship. These are the genuine explanations that we have given. About the days of delay in several judgment by the apex body, there are several judgment where delay is not the material, the time is not the material, but the explanation is. And here we have given the explanation that was with us.
Now, for more than 1 year, they have come to model.
Because MSc Apple are already going for a long time period of time, Your Lordship. They were communicating with the advocate, but after one point of time, these are the genuine reasons, Your Lordship.
No extension of a PDOC judgment. Will not be discussed. There is PDOC. For explanation, but we may. For more, they were.
So we have
You should be a vigilant enough as this.
What is your occupation?
Yes, there was a lot.
Don't know.
complaint, Your Lordship. I have a small business, Your Lordship, but it is not written in the appeal, Your Lordship. We didn't get proper chance to represent ourselves, Your Lordship. That's the problem.
You have practically zero chance of success in the appeal otherwise also. We have gone through the judgment. You cannot change the fact that there was you did not lead any evidence. You only filed written statement, you did not lead any evidence. That fact cannot be changed in the appeal. That cannot be changed. So you, in the absence of your evidence, court naturally came to the finding in their favor. Three of you were driving, so prima facie it indicates crash and negligence act. That is an admitted fact. You in your the written statement itself admitted that three of you were there in the bike. It is already an admitted fact. Only hope for you, maybe you can negotiate some amount. And anyway, this amount is also just 1,70,000. Had it been some huge amount, then also.
I have a very small business, Lordship. I am financially not stable, Your Lordship, at this.
You committed the original sin of not insuring your vehicle. Now you can't come crying to the court. Let will see with result.
In this case, I am paying 2 days time for taking step upon the response number 2 and 3. One has appeared, he has filed written objection.
Heard learned counsel for the petition.
What was made in favor? After delay of 156 days, 156 days, 1,652 days without any sufficient that purposefully from the instant submitted or deposited a single penny purposefully delaying and prolonging the
Any stay order is there?
taking
876 days.
the trick of their ILOC. 25 kilos.
It says 876 by hand.
But no sufficient reason is what reason they had that two lordship. That two what it speaks is the I read your lordship. The petition submits that in order to take decision whether an appeal is filed or not, the files are required to be collected from dealing and process from branch office. Branch office requires legal opinion from its High Court panel advocate before coming to a decision. The branch office took a decision. Matter was reported to the zonal office at Kolkata, and the zonal office, after going through the same to the head office situated at Mumbai for their final approval, and considerable time was consumed, and thereafter the head office returned to the Gauhati branch office a recommendation to file an appeal. Thereafter, branch officer handed over the file to the advocate for filing an appeal, lordship. Again, the advocate required at least 4 or 5 days time to prepare the memo of appeal. Thus, there has been a delay in filing the appeal and is now required to be condoned, lordship. The process of rate taping, lordship, case is identical to authority I am submitting before your lordship. Guilty, lordship.
More than 2000 days delay.
I have placed an authority.
Award is dated
What did it, lordship?
What did
In the year 19 of
21/11/2019 and your date of filing is 21/2/20.
COVID period was
Eh?
COVID period was that was not
I will
as per the office of the High Court, lordship. Registry, lordship, there was delay of 876 days delay, lordship. But here calculation, lordship.
of COVID. And I have also placed an authority before your lordship.
Your period expired before the COVID period.
Lordship.
Had it been within the COVID period, then it would have been expended. But it expired before the COVID period.
Authority I have placed.
Let's get the facts clear first. You are a private company, not a government also. So you don't have that plea also. What is the amount?
Come on, this lordship.
86,000.
Yes.
In para 3, 4, 5.
The policy.
Identical reason, Lordship. In para 3, kindly peruse that your humble petitioner private sector, it is required to act strictly as per the laid down procedure. As such, the files are required to be routed from one office to another and from one table to another after only the final decision is after obtaining the opinion of the dealer well as the advocate practicing in the High Court, and this in this procedural aspect a time is spent. That your humble petitioner begs to state whether an appeal is to be filed or not. This file from the billing and then it is processed the issuing branch case who also requires legal companies advocate before coming to quite natural that the considerable time is spent in moving file from one office from one day taking decision here. In this case, the billing of the office along with the opinion of this was their plea in the para 6 lordship. Your humble petitioner begs to state that this delay is totally unintentional as due to genuine and sufficient present is now required to be condoned so that the appeal is filed along with this petition or along with this petition for delay condemnation may kindly be picked up for admission here. Honorable Court, from a bare reading of hearing before quoted statement, statements are absolutely vague. The procedure of which there is a mention in paragraph 4 is not a statutory procedure. Those procedures are managed.
Who are the other two respondents?
They are owner and driver.
So they have no interest anyway.
See,
And it is
in fact, the vehicle was not insured with us. That is the vehicle was not insured with us. Let's see.
Para 23 of the judgment, Your Lordship. Your Lordship kindly peruse para 23 of the judgment.
That plea was not taken, Lordship. That is why, Lordship, we filed the appeal, Lordship.
Karan? Judgment is not here in the dispute.
And more of the appeal, Lordship, we filed.
Okay. Which page of paragraph of the judgment?
Appeal, page number 16.
Which paragraph of the judgment?
Paragraph 23, Lordship. The instant proceeding.
Yes.
In the instant accident information report exists that at the relevant type of accident, the offending vehicle bearing one so was insured with OP number 3, Lordship. Please mention OP number 3 Reliance.
So where from do you say it's not? Did you file your WS? Did you file WS there?
WS was filed here, but no specific plea was there, Lordship.
Then
That is why.
how can we allow you to take that up here?
Up to you, Lordship.
And most important,
He was-
the certified copy after a period of 1 month. Nearly 1 month. There is no explanation in the confirmation petition.
All right, chalo, we'll pass orders.
Lordship, as per office note dated 18/6/26, postal tracking report shows that notice to respondent 2 was delivered to the addressee. So, Lordship, service is complete. TCR is received, Lordship. It can go for final hearing. Only a date may be fixed, Lordship.
Already heard learned counsel for the pet appellant insurance company. So and so forth. Respondent number 1. As per consignment tracking report, service on respondent number 2 is also complete. Hence, the matter is ready as regards service. Accordingly, the appeal is admitted.
Already
Oh,
admitted.
it is
Lordship.
admitted. List the matter for hearing. TC received. TCR?
Yes, yes, Lord.
TCR also received, hence list the matter for hearing on given date.
Highly obliged, Lordship.
That for that other side has to be present.
Pen for the insurance company, Lordship. Lordship, kindly matter may be sent for the mediation, Lordship. It is already.
Alright, as prayed for by learned counsel for both the sides, the matter is referred to mediation before the mediation center. High Court is the matter again after 2 months.
Obliged.
May I please, my lord? This is 528 application, but more in the nature of mercy petition, my lord. Because on merit, I may not withstand substantially. My lord, in this case, what has happened? The respondent number 2 has initiated a complaint under Negotiable Instrument Act. And after conclusion of the trial, my lord, this present petitioner has been convicted by the trial court. The check amount was 2,50,000 and I was directed to pay 5 lakhs rupees. Thereafter, my lord, I preferred the appeal. That appeal has also been dismissed. And on dismissal of that particular appeal, I approached this honorable court by way of revision petition, and the said revision petition has also been dismissed by this honorable court. But there is a, my lord, subsequent development. There is a payment settlement that has been arrived between the petitioner and the respondent. And that I have brought by way of an additional affidavit. My lord, that particular additional affidavit was filed on Friday, but I have brought that particular affidavit on record today itself. My lord, may kindly, before my lord may go into the additional affidavit, I would like
What
to.
about other side?
My lord, other side, the notice has not been issued yet. So my lord may, before my lord proceed, my lord may just first come to page number 32.
But the question was regarding maintainability.
My lord, my petition is maintaining.
No, it is reflected in the order.
Yes, my
last order.
Yes, my lord. My lord, I will definitely come to the question of maintainability. My lord, may kindly first come to the page 32 of my petition. So I am seeking a stay of this particular order because once the revision petition has been dismissed, the respondent, along with the order of that copy, produced before the trial court, and the non-bailable warrant has been issued against me, my lord. Then, my lord, may kindly come to page number 35. 35, my lord. This order clearly reflected that my revision petition is admitted subject to payment of 1,50,000, which I have paid. That is not denied. Thereafter, my lord, may kindly come to page number 37. During the pendency, my lord, another amount, that is 99,000, that has been paid to the respondent. Now, for a moment, my lord, may kindly come.
The only way out for you is to file a joint affidavit that saying
My
that the
lord,
matter has been
My lord,
settled.
that joint affidavit I have annexed with the additional affidavit.
What joint affidavit?
My lord, may kindly come to additional affidavit.
He has to say.
Yes, my lord.
As you satisfy on the question of the maintainability of the petition, how can he pass a stay order?
No, my lord, I shall satisfy on that, my lord, because subsequently, my lord, an amount, my lord, may kindly come to page. Pagination পড়া নাই নাকি? Pagination দেখাই দাও। Just a moment, my lord. My lord, may kindly come to page 55. This is a joint affidavit, this is a joint affidavit that has been
Page
filed, my lord.
55.
My lord, may kindly come to page 55. This is the fresh agreement on the basis of settlement.
I
So
don't think it
this-
has come. Is it come?
Yes, my lord. Today morning, we have brought on record this additional affidavit.
Good, sir. To page 37 লৈকে আছে 40 লৈকে আছে it is only up to page 41. আগফালে এইটো জানিছো
My lord, may kindly come to page 55. This is the agreement, and I am directly taking to the relevant portion. My lord, may now kindly come to page 58. Paragraph G and paragraph H, my lord, which clearly establish that a further amount of 4,50,000 has been paid to the respondent. And at paragraph H, it is acknowledged by the respondent that the first party has accepted the said offer of settlement, and accordingly, the parties have agreed to execute this agreement on their own will and free consent and without any undue influence or coercion whatsoever. My lord, this particular agreement creates a fresh cause of action, my lord. On the basis of this settlement, my lord, my petition is maintainable. So in total, my lord, for an amount of rupees 2,50,000, I have paid to the respondent complainant an amount of rupees 6,99,000. My lord, he has been adequately compensated in this matter, my lord. And any proceedings under Negotiable Instrument Act is a private nature in dispute, my lord, and this is a civil nature case that has been converted into criminal offense. So, my lord, considering this, my lord, and my further difficulty is that, my lord, I have been asked to appear before the court on tomorrow, my lord. My lord, may kindly come to last page, page 61. The complainant is present, convict is absent, and the date is fixed for my appearance is 23/6/2026. My lord, after paying 6,99,000 for a 2,50,000 rupees check, my lord, it would be highly unfair if I have to surrender myself and taken into custody. At page 61, my lord. So considering this, my lord may dispose of the matter as well, my lord, because there is a recent judgment by the Honorable Bombay High Court.
It will give you limited protection for tomorrow. Disposal, we don't have time now for
Deeply
giving
obliged, my lord.
without being concerned,
Yes.
convinced about the maintainability. It had learned counsel for the petitioner also. It is submitted that pursuant to the last order passed by this court, whereby the petitioner was asked to satisfy the court regarding the maintainability of the instant petition, a subsequent a development has taken place whereby the petitioner, that is the original accused, and the complainant have entered into an agreement for settlement of the entire issue. Agreement dated 16th June 2026. Copy of which has been brought on record by way of an additional affidavit by the petitioner. Stop. Having it is further submitted that in view of the terms and conditions of the said agreement, whereby the parties have agreed to settle the matter for a total amount of
4,50,000.
4,50,000, the complainant stands adequately compensated. And it is further stated that that NBWA has already been issued against the accused petitioner, and the next date fixed for his appearance is 23/06/26. Full stop. Having regard to the above facts, pending decision on the issue of maintainability, the instant petition, I move the that for the present, coercive action need not be taken against the petitioner. Accordingly, it is provided that the petitioner, that the NBWA issued against the petitioner be kept in abeyance till further order is to the respondent. Is the matter again on.
I'm highly obliged by you.
Wait, please, my lord. There is an application, my lord, IA for condonation of delay, my lord, which is registered as IA number 4160/2025, my lord. Here, my lord, the notice was issued by this honorable court, my lord. However, my lord, the service has not been complete. In fact, my lords, I was granted within liberty to serve the other side through any other means, my lord. I have attempted a service, my lord, and to that regard, I have filed an IA, my lord, and affidavit I have filed, my lord, should be in the record, my lord, of dusty service, my lord.
But saying what, affected or not affected?
Not affected, my lord. They did not receive it, my lord. We tried to serve them in the court, my lord, but the matter is pending for the trial court. They refused, my lord. If I may take, my lord, to page number 17 of the dusty, my lord, affidavit, my lord.
So what to do now?
Leave it on, my lord, but there is a little urgency in my part, my lord, because I work in the armed forces, my lord, and there is a judgment against me for recovery of my money, my lord, and my lord, my authorities are holding my salary account and they are trying to deduct it because the order is as such passed by the learned trial court, my lord, the executing court, in fact, my lord. That is my only difficulty, my lord, because the entire order has been passed ex parte against me. Order which I am challenging before this honorable court. And they are deliberating, my lord, they are not accepting the service, my lord. They are not receiving.
What about the ordinary service? What is the
That has
report?
not returned, my lord. ID card has not returned back, my lord, as per the last office note.
When was it sent, last one?
In the month of March, my lord.
Took steps in the month of March, then this also you could not serve.
My lord. They have not been receiving, my lord. That is a difficulty.
What is this order of the court? We are not able to follow. Both sides are present.
My lord. Attempt was made, my lord. In fact, page number 15, my lord. First, an attempt was made on 25/3/2026, then on the 25/4/2026, my lord. 2 dates. They did not receive, my lord. Firstly, they have stated that in the order 25/3/2025 that he doesn't have instruction, my lord, the council. The next order, it is clear that, my lord, both the parties are there, my lord. They did not want to receive it, my lord.
All right, heard learned counsel for the applicant. None appears for the respondent. It appears that pursuant to order dated 20/0/26, the petitioner had taken steps by petitioner had sought to take effect service by way of Dusty, but without success. Petitioner has filed an affidavit in this regard, enclosing The order dated 25/03/26 passed in mis-execution case number 1 of 2025 by the learned additional district judge Dibrugarh. Appears from the said order that the executing court had apprised the learned counsel for the decree holder about the pendency of the preferring of the present connected appeal along with the condonation application. And when the copy was asked to be accepted by said learned counsel for the decree holder, it was submitted by him that he had no instruction to receive summons on behalf of the decree holder right now. And the matter was left open. Subsequently, it is reflected in the order dated 28/04/26 that the other side that the decree holder is not receiving the summoned copy of the appeal pending before the High Court. From the above appears that the decree holder stock respondent has been deliberately avoiding service of notice. The same service on the respondent is to be complete. Post the matter for list the matter again on reopening give a date.
Deeply obliged.
They have been taking time in this case because what I am pressing then say the petitioner has already undergone 8 years, 2 months out of 10 years, Lordship. And on the last few occasions, they are taking time, Lordship.
They're just one time being, not for the day. Just
May it please your lordship. My lord may kindly peruse the office note dated 18/6/26. My lord may call for the track
per
report.
office note dated 18/6/26. Press notice was issued on 15/6/26. So hence I wait service list again on 4 weeks.
Public.
My lord, there was a delay of 129 days in the connected appeal.
He has already filed objection.
Copy was not furnished to me. No copy was furnished to me.
No copy received.
No.
Third learned counsel for the petitioner. Learned counsel appearing on behalf of Mr. Moore.
I am R.K. Moore.
And
Appearing on behalf of Mr. B. Fugon. Submits that an objection has been filed, but learned counsel for the petitioner submits that he is yet to receive a copy of such objection. Hence, release the matter again on so and so application. In the meantime, copy of objection, if filed, may be furnished upon learned counsel for the petitioner.
My lord.
Actually, see, delay consumption petition, delay of 73 days, matter has come for the first time. Notice you have to.
Alright, notice. Third, effort for donation of how many days? How many days?
73.
73 days. Bring the connected appeal list to the respondent. List again on and so.
Actually, this is a delay of 80 days.
Same order. 80 days.
Right, sir.
Unappears list of the
This appeal is prepared by the insurance company, Lordship, and there is a delay of 3 days, Lordship.
3 days.
3 days, Lordship.
Even if it is 3 days, we have to issue notice. Issue. A has been preferred seeking delay of 3 days.
Bless.
List again.
Lordship, this is a delay condonation petition condoning a delay of 4492 days.
Alright, same order, 449 days.
Lordship.
85 days. Okay, same order.
I think there is some confusion between 52 and 53.
What confusion?
Item is 53.
Then what is the difficulty?
My knowledge friend is saying
Sorry, Your
he is
Lordship.
appearing for 53.
My item is for 52, Your Lordship.
52 we have passed already.
Lordship, kindly 85 days, Your Lordship.
Yes, we have issued notice.
Lordship, in respect of respondent number, Your Lordship, kindly allot
Right?
respondent number 1.
Petitioner may take steps by way of dusty service on respondent number 1 in item 52. Okay. 53 same delay.
Yes, delay 308 days.
308 days, item 53. Okay. No dusty here.
Oblige, your lordship.
তা থাকি গ'ল নহয় হৈ গ'লতো এইটো দিলো notice. এইটো কিমান আছিল 6 just call for the CD. None appears. Call for the CD. This again. No? আছিল no? Cannot wait.
Item 44.
What was this?
There is an IA number 445 of the 2026 for suspension of sentence and release the petitioner on bail. Lordship. In this case, the petitioner is convicted for a period of lordship 10 years, and they have already undergone lordship 8 years 2 months around. Therefore, I filed this petition for release because this is a case coming from has been come from lordship jail. Lordship, it is a jail appeal. Lordship, and they could not arrange advocate on time, lordship, and file any appeal. The legal aid counsel for the petitioner's lordship. Substantial part, lordship, they have already undergone, lordship. In the lordship, the period of lordship custody, lordship, judicial custody. For 79 also provides for lordship releasing the petitioner on bail, where they have already undergone half of the lordship punishment, lordship.
This is post conviction.
Yes. The appeal is a lordship is a continuation of trial, lordship. The 479 is also applicable to in the appeal also, lordship. Otherwise, lordship, after few days, this appeal will become infructuous, lordship.
Then let us post the appeal for hearing.
LCR has not come yet.
LCR will come by reopening. Not yet called for, I think.
Already called for, lordship. 129/5/2006. They have already filed detailed objection, lordship, against the petition. They have already filed their written objection.
Where is that? What is the objection? Objection. Have you brought it on record? You have a copy?
Yes, Lordship.
Could share, good time.
Last two occasion, Lordship, they have
I'll give you a copy of the objection. Let us see.
in the last part, Lordship, they made objection, Lordship, against the suspension. Long affidavit, Lordship. In last part, here, Lordship will find the objection in suspension of sentence. The main objection with regards to, Lordship, the merit of the case.
Yeah, of course, they will argue under merits because you are not now an under trial. You are a convicted person. In order to succeed in this application, you have to show why the judgment is wrong.
At this stage, Lordship, I am not, my contention is regards to they are undergoing prior, Lordship. No say today, Lordship, on merit, Lordship. Because since 479 provides for release of the Lordship, the under trial who has completed, Lordship, half of the punishment, Lordship, or 1/3 of the punishment.
That is for under trial.
The appeal is also, Lordship, is a continuation of trial.
Any decision in that regard? That it is applicable only
There is-
also to.
There is decision, but today I could not.
So why have you come here today then, if you are not here with the decision?
On the last occasion, Lordship was trying to.
Don't know. I don't remember. We say a lot of things in course of, that doesn't mean that you can go and come back without doing your homework.
Copy or their objection copy itself I received today morning.
It is you who is insisting on taking up today. So that is what we are saying. If you are so ready, then you should submit. You should be ready, fully ready. Answer the queries of the court. On merit, we find no defect. Then why should we suspend the sentence?
Lordship, I fix it on then 25, Lordship.
All right, 25th. You can go ready. Hard done at counsel for the applicant. Is submitted on behalf of the respondent. And CB data and objection has been filed. On file. When did you file? Friday. Okay, date. Same is not on record. History to place the same on record and release the matter again on 25.